Alright, it appears that I am recording. Is that correct? I got mic connected. Alright, and I believe that the connection should be good. I've tested it. I think I have to be quiet though, because even though this is a soundproof room with this nice board that absorbs sound, I can kind of hear the other person on the other side rolling something across the desk. I don't know what they're doing. It's weird noises. So let me start out with a meeting that I had with my lawyer over the Zoom, and somebody asked, I want to keep this as general as possible here. Somebody asked a question, and this should play.
What do you guys think about at this stage here? So, can I share your rough draft as I start trying to stoke interest, or as I continue stoking interest in Amicus briefs? Yeah, you can. Just make sure you let them know that it is a rough draft. I mean, they'll just, you can just highlight the fact that it hasn't been signed yet. I mean, they'll be able to see that. But yeah, I have no problem with you doing that.
Okay, I can actually hear her talking now. Let me look in the chat and see if anybody can acknowledge hearing that. Not the neighbor talking, but what was said on that audio player. It's a little slow. Alright, getting close to the chat. Okay, it looks like, oh, people have Satan. Okay, I can actually hear her Zap. Thank you for acknowledging. Let me look in the chat and see if anybody. I had to change their names. Hearing that, just because I don't know. Like, I think my lawyer wants to be like anonymous or doesn't want to be contacted or something. That audio player. So Phil approved. He said it's okay to write amicus briefs. So I want to make that actually hear her thinking clear, acknowledging, and see if anybody. I had to change their names to go into because I don't know. Like, I think my lawyer wants to be like, fine. I want to learn more anonymous or doesn't want to be contacted or something. Because if somebody wanted to write, Bill approved an amicus said it's okay to write. What all does that mean? It's kind of open-ended. I want Circuit Court of Appeals in Louisiana. Zap thinking clear, acknowledging, and okay. I had to change their names to go into that screen. I don't know. Like, I think my lawyer wants to be like, fine. I want to learn more anonymous or doesn't want to be contacted or something. Okay. If somebody wanted to write and Bill. Approved. Amicus said it's okay to video. What all does that mean? It's kind of open-ended. Shrink. Third Circuit Court of Appeals down. Zap thinking clear, acknowledging, and okay. Third Circuit. Now I want to show. Oh, I know what I want to get rid of. I don't know. Like, I think my lawyer wants to be like, fine. I want to learn more anonymous or doesn't want to be contacted or something. Okay. If window. What is that should stay. Okay. But I do want to increase video. What all does that mean? It's kind of open. Because if we write, if anybody is interested in actually writing, okay, Third Circuit. Oh no, what did I just? Oh, I know what I want to get rid of. If anybody was interested in writing a learn more anonymous or doesn't want to third or something. Okay. My memory is so bad. What is that should stay amicus brief. I had to look up. I can't even think of the name. Amicus brief. It's kind of open. If anybody wanted to write an amicus brief to the Third Circuit Court of Appeals, they don't really take email. They take only, I think, letters or something. So, oh. Yeah, they need back feeds. So bad. What is that should stay amicus brief. I had to look up. There's no sound. Amicus check. It's kind of open. If anybody wanted to write, see, I got Mike. It looks like an amicus brief to I can take down the video capture device. They don't really take email.
Yep, that's about it.
They take
It looks like
only, I think, letters.
I don't know what the...
So, oh, yeah, I need back to know what the problem is. There's a problem with the mic.
I had to look up.
There's no sound. I turned down the.
If anybody wanted to write,
See, I got mic. It looks like it's
an
working.
Amicus brief too.
You know, it is moving a lot on the video capture device. They don't really take email.
Yep, that's about it.
They take
It looks like
only, I think, letters. Oh, oh, I see. Oh, yeah, I need back. Okay, desktop audio. Alright, I turned down desktop audio too. And now it's only mic. Okay, I guess that should be good. There. Alright, so I think I see I had two competing audio sources. Desktop. I wanted to use desktop audio 1. Okay. Alright, so yeah, the Court of Appeals has the ability to write a, what is it called again? Oh my god. If I wanted to do a friend of the court, if I wanted to write a friend of the court amicus brief, friend of the court, let's see, this is a part of the Third Circuit Court of Appeals, and it's the largest one of the largest of the 5 circuit courts of appeal, and there's 21 parishes in the Southwest. Let's see, and I think it's all in Louisiana. It's a little busy at this time. Be the first to ask a question. Okay, sure. I'll be the first. Let me ask this question. How do you accept Amicus briefs? All right. My question was posted to the community of the Third Circuit's Court of Appeals of Louisiana. Alright. Well, that's taken care of now. That was easy. Let's see. What would have happened to you if you ate that mushroom? Okay, so what? There shouldn't still be an echo. Okay. Let's see. Court of Appeal. Alright, so I guess I can go into that website, law3circuit.org. I guess the others are law 5 circuit or law 2 circuit. Circuit Court of Appeal, Third Circuit. They take up the whole heel of the state. Welcome to largest of the 5, 21 parishes. The parishes are, the Third Circuit was created in 1958. Let's see, 21 with 5 judges. Started in Lake Charles. 14th. Let's see, effective 78. Increased judge from 9 to 12 in 1987. Construction of a new courthouse began in 1990. Occupancy. The court's location was a donation from A.P. Leonard's. Records custodian. Ah, there's an email. Records custodian. So there's a records custodian. That might be interesting. He will be arrested in a minute. Okay. Gay shame. So there's a custodian. What do I ask? Please note, is for general inquiries only. Document filings are not permitted. So is the amicus brief a document? Is I can't ask. What's the deal? I don't see. Oh, no. Wait a second. Which channel am I on? Oh, I see. I'm on my travel channel. What? Okay, let me just check something here. Okay, that's still up. I guess I'm on my travel channel. All right. So I have to log in. All right. I have to log into my travel channel. Well, I think I know it. Okay, yeah. Okay. I forget which channels sometimes. Yeah, yep, that's on my travel channel. Okay, because I wanted to do a survey. Wow, look at that. I was on the wrong channel the whole time. Okay. Alright. Does... Wait a second, did I just... No, I'm confused, because I got more than one window popping up. Did I just give away... Oh my god. Okay, so... Yeah, I got confused there, and... I popped up a window I didn't want. So, yeah, I want to just keep it on the Court of Appeals. Let's see here. Alright, does... Okay. Documents... Alright. How long can I make my question? 100 words. 105, okay. Alright. Okay, please note... Okay. Can... Our documents... Is an amicus brief... Is an amicus brief a document? Is an amicus brief a document? Document, okay. Alright, I can put that on top. Paste. No? Isn't it? Okay, let's ask that question. Alright, so we're looking at the records custodian Renee. And she answers general questions with the Third Circuit e-court system, employee court calendar. So there's really not much to go off of here. Zoom attorney guide. Despite not being physically in the courtroom, the Zoom session is a court proceeding, an extension of the court. An appeals court oral argument session on Zoom will operate similar to a courtroom hearing. Yep. The rules of the court shall be promulgated by posting a copy to the Louisiana courts. Alright, what is people saying? There's a very good reason we have never seen Travis bathe himself, because he doesn't do it. That is true. I do not bathe myself. Let's see. Louisiana law mandates a set procedure for the preparation of appellate courts. Let's see. Press releases. Caricature Jack Watson passed away. Dang. He lived a long time. New Chief Justice Sylvia Cooks. Just like last month. Okay. Then we get a background of her information. Their information. There's a little thing called Google. I can't do surveys on Google. Acrobat. Okay, am I even... That's going to show, isn't it? Yeah. Okay. Pioneering first woman Chief Justice. So I could get Sylvia Cooks, the first woman pioneering, opening the door to women. It's the worst hurricane. In the aftermath of the worst hurricane disasters. She just started last month. I didn't see any disasters. Can't just use 2 fingers to make this bigger? Alright. A public education partner. Commitment to education. Lecturer. Okay. 92 to serve as a third. First elected in 92 to serve as on Court of Appeal, where she presided for 28 years. Wait a second. I thought she was just... Oh, that... What? Alright, why am I reading this? This isn't the news clip. Oh, that was in 21, okay. Huh. It sounded like she left for a little bit and then came back. Does not accept fax filings without prior permission. Ethics, dress code. Appropriate men shall wear a coat and tie, no denim is allowed. Is there more on the dress code? Oh, come on. Alright, I'm gonna click end poll. Bums lose their patinas in the summer from all the sweating. It's for general inquiry. Is Amicus brief a document? It is? Okay. Huh. So I want to consider it a document. All counsel appearing before the court shall be dressed appropriately. And then that's it. No denim is allowed. All counsel, that's for counsel, so that's a standard they set for the lawyers, not for people. Okay. Meet court judges. Meet the judges, yes. Out of the 12, we got Cooks, and they all have their phone numbers there. I have no idea. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10. I only count 10. Oh, 11, 12. Okay. Alright, so there's 12 justices. It sounds like Cooks was the most recent appointee last year. Okay. You just click on the name and they just give you the name again. Oh, whoa, I was told to look out for one of them. Gremlin? Oh, he's got a rock and roll history. Okay. Bossier City. Alright. Who am I? Okay. Who the... Oh, Van Kaiser is who I have to look out for. He's the one to be concerned about. There's a 3 out of 12 that will be chosen. I don't know how that is chosen exactly, but these are the pool. It's not a jury pool. It's a judge pool. All right, Perry, Kaplan. I don't know why these judges care about reading people's tweets and all that stuff. It's hard. That's really hard to believe. Or if they care that... Okay, so it looks like... Well, okay. Out of the pictures, Ortega... Okay, out of these pictures, we got... Okay, one... Okay, 2 pictures... 3... Okay, just a description. 4, 5, 6. Okay, half of them have pictures, and they're all white. So, if I were to guess based on pictures, half of them are white. All right, that's the best I can do without researching. Let's see. V15 says if it smells like unwiped. What? Is somebody swearing? Huh. I don't promote swearing on this channel, so I'm gonna have to time you out there, buddy. Let's see. Judges. Okay, it's Travis. He's getting arrested anyway. I've only been in jail, not prison. All right. So I am looking at. Okay, Phil approves. Okay, meet the judges. We're looking at that. All right, I'm talking about amicus briefs. You would be writing an amicus brief to one of these, or three of these 12 judges on the appeals court, and let's see. That's the meet the judges, but you don't just write to them. Yeah, because they also have key personnel too. Apparently there's some you go through some lawyers before you can get to the judges. Let's see. Assistant director. No, they're clerks. They're like lawyer clerks. All right. Career opportunities. Limited language. All right. Language access coordinator is the same as she's the records custodian. Renee is the records custodian and the language access coordinator. Okay, we're looking at just that website. Now I am getting out of it. Let's see, it's Windows Capture 3, and yeah, I just want to delete it. Out. Alright. I have there's different levels of outside influence that goes into the courts, and this isn't quite an amicus brief. It's more, it's Robert who showed up at my trial, and he made observations and then wrote down his observations. Let's see, Billy says, Mike Stevens, I had to go to jail once in my life. A meth head attacked me in the street and accidentally broke his little arm. Charges were later dropped. Alright. I'd imagine that amicus briefs would be filed. Yeah, anybody, I think anybody who's seen the arrest video could file an amicus brief. Grandma believed it. And it's, okay. It's similar to this, but this was going to be submitted as like a witness testimony for one of my hearings on the city court level. But you can file your observations as a friend of the court. Is this okay? I'm gonna just mess around with something. Or want to play an audio on the city court level. Is there echo? You can file
What do you guys think about
observations
amicus briefs
as a friend
at this stage here? So,
of the
can
court.
I share your rough draft as
okay,
I start trying to stoke interest, or as I continue stoking interest in amicus briefs?
Want to play an audio on the
Yeah,
city
you
court
can. Just
level.
make sure you let them know that it is a rough draft. I mean, don't just, you can
file,
just highlight the fact that it hasn't been signed yet. What do you guys think about amicus briefs? But yeah, I have no problem. Just stage here, so can I share your rough draft as I start trying to stoke interest, or as I...
Alright. Pretty much just stopped it there. So I think I want to get more familiar with playing around between audio on the computer and audio on the mic. Grandma's story, it's a story you tell your grandma about what happened. Oh, you don't want to shock your grandma. Somebody ate 500 gummies? What? The brief I have here, supplement, okay, it's, let's see, the legal basis for a motion for a new trial. This was to try to get a new trial. Let's see. Oh man, so I gotta shrink that. Okay. Alright. Oh, we moved a little fast, didn't we? Let's go back. Okay. Now this is for a new trial, and then we're fighting to get a new trial on the city court level, but Judge Owsley said it was out of his jurisdiction to decide. So, verdict is contrary. The defendant has discovered, since the verdict or judgment of guilty, a prejudicial error or defect in the proceedings that, notwithstanding the exercise of reasonable diligence by the defendant, was not discovered before the verdict or judgment. The court is of the opinion that at the ends of justice it would be served by the granting of a new trial. Okay. Alright, so here we go. As of back in January, February, March, April 28th, defense counsel received an affidavit from affiant. So this is an affidavit from Robert Parker, Pig Channel Robert Parker. Maybe I could bring that up. YouTube. Okay, he just put out a new video apparently. So we got Robert Parker's affidavit. Pig Trader Robert Parker. I'll open this up and take a look. Window capture. And okay, and alright. Let me play around with this. Put this there and my video in front. And get to the webs. Not there. There. Alright, and he put out a new video. He made this affidavit for me back at the end of April. And there's videos, but I don't... Oh, that is a new one. Lady Librarian Interview. And somebody said in comments that somebody else had something to say. Alright, let's see if we can see this okay. Alright, I can increase the size to right there. No Shy Girl. Now, I'm reading this for the first time. Alright. LaCour here, Parker in court. Carmela Parker, who ran against all-sized... Her last name is Parker? I wonder if it's maybe if it's like her brother who might have married the librarian. Ran against all-sized and lost as president. She's president of Crime Stoppers. She's president of the snitch chicken delivery. Should have never thrown... She's president. LaCour... Who's LaCour? Should have never thrown Carmela under the bus, telling her she helped her with fine points of testimony. Also to state that he has been there before, delusional ranting and shooting up the place. Shooting... Oh, me, right? Poor thing needs psychiatric help. So far, I've not found any article about circumstances like that. In the end, even though he advised her to file a police report on those threats, she didn't. And didn't have proof. Why is that? She's torturing herself with her own drama. No one did a thing to any of these people. The old bait and trap is exactly what their drama has done to Mr. Hines. At this point, I'm quite sure these people are armed and trigger happy in their delusional world of fear. Yeah, you wonder. As much fear? Following the man around us, not a sign of fear. It's a sign of stupidity. I'm going to give that a thumbs up. I think that's interesting. And then there's more. Carmela helped Rosalind. I don't know of this. Say more. Their family, Robert. See, this is a real new revelation from No Shy Girl here. Because I didn't... I guess, you know, No Shy Girl never really popped up until Louisiana. That's not a familiar name to me. Their family, Robert, also this police officer, leading a witness, concocting a story with no basis or fact, actually instilling fear, telling her Travis is baiting and trapping, just making it worse, crafting a horror story. Travis' itinerary is online. He was not in Louisiana, as she claims. Yeah, that was an interesting claim. Going back to the prior year takes time. It can be done. We'll take a look later. Pig Trader is a Parker. Different race, yes. See, that's what I wonder, because the librarian is married to a black man, and they talked about this female judge being the first black lady getting becoming the city judge. Can anyone say leading the witness? TGIS, whole interview would have thrown out in any other state. Show me on the job where Travis hurt you. Okay, am I showing this even? Is this even? Alright, it looks like it. Different race, yeah. Alright, no wonder no one goes here. Oh, okay, spying Dutchman, he's an outsider. So the librarian was right to call the cops, and the cops had the right to ask for his ID. Case closed. Okay. Sounds simple enough. And yeah, we just go back and forth. Oh, Daniel Bulquist had something to say. What? Wow, I didn't know Daniel put out videos. I always thought he was just a commenter. Alright, he's got a few. Airstream interior end cap. Alex gets orange. Wow, look at that. I'll have to subscribe. Check those later. Oh, I see it doesn't even show. Alright, so what's going on here? I'm not showing the full screen. I don't want to increase. So I guess a lot of this that I've been looking at is not even visible. Let me shrink. What happened? Alright, just keep it like that. Alright, so yeah, Daniel Bulquist has his own channel. Alright, and not that, yes. Alright, and then Pig Trader has this new video which I have to watch. So I'll just download it and uphold the Constitution is not an expression of any desire for... Oh, you got it. Yeah, Phil said that you should give a warning. He's given plenty of time to read that. 18 months? Wow, that's a long time to be in jail. His channel will be gone, his car will be gone, and any interest in what he does after 18 months will be absolutely useless. Yeah, pretty much 18 months in jail is like just pretty much dying in the social media world. You get thrown in jail for a month or two, that's long enough to be forgotten. It's like being thrown in, it's like dying. Let's see, downloading, keep this window up. So you don't, if you want to be relevant in the social media world, you can't get thrown in jail. Kind of like what happened to, and I'm bad with names, that guy in Colorado. I forget his name. Alright, so we're reading Pig Trader. We know Pig Trader has a new video he put out, and he got some real interesting information in the comments about somebody being coached and the librarian bragging about being coached by the president of Crime Stoppers. The president of Carmela Parker is the president of Crime Stoppers. You know, Eric Brandt, that's the guy. Yeah. Thank you. Thank you, Mike. Eric Brandt. See, it's so easy to forget names. It's just, if you're not repeating them every day, you step away from that, you start forgetting. So Carmela Parker is the president of Crime Stoppers, the same Crime Stoppers that pays $1,000 if you submit a tip. So I think there's a connection there. They're giving away free chicken deliveries to the snitches straight from the police station, and even Prosecutor Benjamin is taking advantage of them free chickens. It must be good if he likes them, right? Or what are his standards? What would be like, comment, share, subscribe? What would be his standard for chicken? Does he like thighs? Does he like breasts? Does he demand a real flavorful chicken? I mean, their standards are pretty low for arresting us. So it'd be like he would have a high standard for the chicken and a low standard for arresting the cook. If the cook messed up the chicken, they could be arrested and thrown in jail on a low standard, but for a high standard for the chicken. If you don't meet the high standard for a chicken, it doesn't take much to get you thrown in jail. Alright, he prefers white meat. So, alright, we got low standards, high standards, more low standards, but like I say, the city has high standards for the community, but there's they follow low standards to arrest us. Alright, I got this up twice. I don't need it. I don't want to keep this up any longer, so I can just hit delete and go. Get out of here. We're reading this media source. So the affidavit was pig trader Robert Parker. He just put out a video that is notarized in California and sworn under perjury. And this is a while ago, May 2nd. In the presence of a notary and 2 witnesses, a reading of this affidavit indicates that Article 851 and even 5, if the court disagrees with factors 1 through 4 apply in this case, especially when read in conjunction, defendant's pretrial motions, pro se. Okay, I'll play because this is a video. This is a PDF that I turned into a video. Ah, jeez, and I stopped it? That's not... Yeah, replay. I meant to hit a pause. Motion to recuse. I have to hit pause. Oops. And I moved it. Oh, gosh, too far. Motion to recuse. This affidavit is being attached as Exhibit A. Robert Parker, pig trader, contacted defense counsel and indicated that because he lives in San Diego, he never showed up. Alright, that's just too far. To come twice and into a city that's hostile, I made sure to, at Phil's request, cover his all contact information. Sworn affidavit, Exhibit A. Robert Parker, residing in San Diego, California, declares and swears that the following is true and accurate and correct to the best of his knowledge. I attended every minute of the trial on April 11th. I am not a lawyer. I'm 56 and I have experience with legal proceedings and served on jury duty. Oh yeah, and I've taken time to attend about 5 trials just out of interest. I have a PhD in mathematics and is that PhD of mathematics out of, what was the name of that? Alright, I want to go to Google Maps, because he told me that he did a lot of his studying for mathematics and statistics out of Grinnell, Iowa. PhD possibly out of Grinnell, Iowa. Highly analytical minds. I've paid attention to civil and criminal procedure in my own litigation and the trials I have observed, both as a jury member and an interested citizen. Alright, let's see comments here. Alright, I'm out. Okay, looks like the comments came to a standstill. Standards change depending on issue at hand. Yeah, they do. That's a standard changes by the time of day and the perspectives. Okay, I'm back to in pretrial. Mr. Hines asked Judge Owsley, Your Honor, please also state for the record Your Honors and prosecutor or DA's office public office bonds number as required by the public officials pursuant to revised statute 42-181. Judge Owsley dismissed the matter quickly, saying not now, and denied. The Hines trial started at 9 a.m. One of the key witnesses, Officer Favors, being one of the 2 officers who first encountered Travis in the magazine room, was described by Judge Owsley as having a medical appointment scheduled for 1:30. I heard Favors say, the clerk told me this trial would be done before noon. This indicated to me that there was some pre-established plan for the trial that did not include Hines's active defense. My observation was that Hines's defense was effective. My observation was that Hines's effective defense was ignored by Judge Owsley as further indication to me that the trial was pre-planned. The court did not allow a lunch break until 3 p.m. I observed that this schedule took a visible and obvious toll on Mr. Hines. I observed that by about 2 p.m. that Mr. Hines was not functioning well. I observed that Mr. Hines was having trouble adjusting his scripted questions to counter the many restrictions that have been applied by Judge Owsley in sustaining Mr. Benjamin's objections. Earlier in the day, I had observed that Hines was reacting well to objections and making adjustments to his questions. But the afternoon deterioration of Hines's energy and mental acuity were evident to me. Well, yeah, I get tired easy. Hines was visibly exhausted, and he told me during the 3 p.m. break, I don't think I can get any questions answered anymore. On Hines's cross-examination of witnesses, Clyde Benjamin kept objecting to questions on the ground of scope, that the subject had not been covered on direct examination. Whoops. Let's see, where... That incorrect. Clyde kept objecting that the subject had not been covered on direct examination. On each occasion, Judge Owsley sustained the objection. I thought this was an incorrect ruling, and after trial I studied and confirmed as much. In a repeated pattern of what I viewed as unfair disruption of Mr. Hines's cross-examination, Mr. Benjamin made outbursts of expressions of insult and impatience with Mr. Hines, and was soon joined in expressions of impatience by Judge Owsley, who continued to incorrectly sustain the scope and objections. Mr. Benjamin objections were not succinct, they were long and drawn-out objections that frequently coached the witnesses on how to address the questions. During the cross-examination of Officer Miller, displaying impatience with repeatedly sustaining Mr. Benjamin's scope objections, Judge Owsley offered that Hines could choose to call Miller for his own direct examination. Mr. Hines chose that path, calling Officer Miller on direct examination after the prosecutor rested on his presentation. On Hines's direct examination of Officer Miller, Mr. Benjamin commenced objecting that Hines had not established foundation for his questions, and that Hines should not be allowed to rely on previously established foundation, but was rather required to start anew. Judge Owsley sustained these objections. Also on Hines's direct examination of Officer Miller, Mr. Benjamin objected that Hines was not allowed to use leading questions on direct examination. Judge Owsley again sustained this objection. Officer Miller appeared to me by his testimony to be a witness who was hostile to Mr. Hines's freedom. After Hines could not ask leading questions or any questions following up on earlier testimony, Hines stated clearly to the court that he just didn't know anything about foundations, and Hines gave up trying. I'm not even a lawyer, but as a layman, I observed rulings that just didn't make any sense from me from a perspective of fundamental fairness. My studies afterward confirmed that I was correct. Before trial, Hines showed me exhibits produced by the office of Mr. Benjamin. Included were 2 documents created by Officer Davis. The first was his police report dated January 22, 2022. The second was titled as Statement, dated January 26, 2022. Mr. Hines planned to impeach Officer Davis with a comparison of the 2 documents, because the later writings contained a large number of factors of suspicion about Hines that were not included in the earlier police report. On cross-examination, Hines tried to present Davis with the second document, the January 26 statement. Mr. Benjamin objected that this was a hearsay document and made a best evidence objection, stating that the best evidence is from the officer's testimony, and he's sitting right here. Judge Ousley sustained the objection. I knew that on both hearsay and best evidence, this ruling was incorrect on the law. Before trial, Mr. Hines confirmed during his preparation that he was delivered to the court a thumb drive containing the evidence produced to him by Mr. Benjamin's office, and the clerk assured him that the court would be able to display the evidence for Mr. Hines during trial. In trial, when Mr. Hines tried to present one of the video exhibits, he was told by Judge Ousley that he could not because the thumb drive had been given back to Mr. Benjamin's office. Despite the fact that all of Mr. Benjamin's exhibits, as produced to Mr. Hines, were resident on the clerk's computer awaiting presentation by Mr. Benjamin, Mr. Hines was prevented from using any of the video evidence until it was first presented by Mr. Benjamin. Hines attempted to question Officer Miller on his undated statements, which contained many items of suspicion about Hines that Miller admitted in his testimony on direct examination that he did not have before Hines's arrest. Again, Benjamin objected on best evidence grounds because Miller was sitting right there. Objected on best evidence grounds because Miller was sitting right there, and Judge Ousley sustained the objections. The equipment used for audio and video presentation during the trial was of substandard quality for a courtroom. I was in the front row, and audio played from a crackling speaker and could barely be heard. I objected from behind the bar, indicating physically to Judge Ousley that I could not hear, and I held up a speaker that I had brought, offering it to Judge Ousley. He waved off my objection. Video was displayed on a monitor I estimate as being 18 inches on diagonal. I had to get out of my seat and walk up to the bar to get as close as possible, and I could still not hear the words or see the video. I was closer than the witnesses testifying. Mr. Hines asked witnesses on cross-examination if they heard every word of the video evidence, and each witness said yes. These answers were untruthful. My hearing is good. I was equally close the sounds than were the witnesses. While Rosalind Parker was the witness, some video was displayed. Miss Parker had to come out of her testimonial seat in order to view the video. She stood next to Mr. Benjamin, and while the video played, Mr. Benjamin and Mrs. Parker whispered to each other. Mr. Hines pointed this out, objecting loudly and pointing. Judge Ousley was standing as if to watch the video, and he witnessed the improper communication. But upon Mr. Hines's objection, Judge Ousley turned his back to the Benjamin Parker meeting and made no ruling on Hines's objection. During presentation of Officer Davis's body-worn camera video, Judge Ousley did not even observe the evidence. Judge Ousley was turned away from the video monitor, displaying by his body position that he did not care to see the evidence. During the presentation of that video, Mr. Benjamin frequently talked over important parts of the dialogue. When the video was played again by Mr. Hines on cross-examination, both Mr. Benjamin and Judge Ousley again spoke over the video and did not allow Mr. Hines to present the witness with the parts of the video that impeached the witness's testimony. Judge Ousley dismissed the interruption, saying they didn't matter because he knew that body cameras don't turn on right away. Mr. Hines asked Officer Davis a series of questions about the individual items of suspicion that were listed in the officer's reports and statements. The questions were given proper foundation, as in this example from trial. Q. Miss Parker told you the man was wearing a green-colored jacket. You see that in your report? Yes. That's not exactly a green army jacket like the dispatcher said, right? Correct. Green-colored jacket versus green army jacket. Did your suspicions go up, down, or stay the same? Stayed the same. This questioning was shut down when Hines asked Davis, if I want you to focus on the level of suspicion, okay? Because as you investigate, suspicion can increase or it can decrease, right? Mr. Benjamin objected to this, that this witness was not an expert and that the phrase level of suspicion was vague and ambiguous. Judge Owsley sustained the objection and added that Mr. Hines couldn't reference a level of suspicion because there's no way to measure a level of suspicion. It can't be quantified. After completion of direct cross redirects for Officer Davis, Judge Owsley asked his only set of witness questions from the bench. He asked Officer Davis if he took notice of Mr. Hines' cameras and asked if that raised suspicion. Officer Davis answered yes. Each of Officer Miller and Favors, this same question set was repeated. It was clear to me that Judge Owsley did not know that video recording public officials in a public place is a First Amendment protected activity that cannot form any part of the basis for reasonable suspicion that a person is associated with criminal activity. Judge Owsley did not display understanding of what it means that certain activity is protected. Mr. Hines asked Officer Davis these three questions. Did Mr. Hines ever refuse to give you his name? Yes. Were you able to investigate what had occurred at the library without knowing the identity of the defendant? No. What investigative questions did you ask? I couldn't. When exactly did you develop a reasonable suspicion to detain Hines? Immediate, as soon as I arrived. As Mr. Hines was cross-examining Officer Favors, he asked a series of yes-no questions about her training. To the first of these questions, Favors had a puzzled look, and she was scrunched up in her face. She looked over at the bailiff, who was nodding yes to her, and she then answered yes. 4 questions in a row. Favors got her yes-no answers from the bailiff. Then the bailiff looked toward me, and I held his gaze and stared at him. He looked back and forth between me and Favors as the questioning continued, and he offered her no more answers. In pre-trial, Mr. Hines stated exactly, Your Honor, I ask that the court exclude and sequester the witnesses. Judge Owsley only excluded witnesses from viewing testimony. The witnesses all gathered in a room opposite the courtroom. I managed a stack of documents for Mr. Hines. Each was titled in large bold letters with the witnesses' names. Returning from a break, I noticed one of the 2 copies of the Miller document was missing. A few minutes later, I looked into the room where witnesses were gathered and saw Officer Davis holding the Miller document, discussing it with Officer Miller. When Officer Miller was cross-examined, he was asked the same questions posed to Officer Davis earlier. Have you ever heard of a Terry stop? Davis had answered earlier, yes, Terry vs. Ohio, and faced the follow-up question, were you trained that to conduct a Terry stop you had to be able to articulate a crime that has occurred, is occurring, or is about to occur? Were you trained that you need at least one of those 3? Davis answered yes. After I had observed Davis and Miller discussing the Miller question, Officer Miller's answer to the first question was no with a quick, smug shake of the head. When Hines asked a follow-up question, Mr. Benjamin objected, with success, that it lacked foundation because Miller just testified that he doesn't know what a Terry stop is. The combined judgment sentence phase had neither a break in time or a clear linguistic break between them. Judge Elsley spoke of the many wrongs of which Hines had been accused during the trial, without regard to whether any of those accusations had been made to police before Hines was detained and arrested. Judge Elsley did not make any temporal distinction between allegations of suspicion known to the police before as compared to after Hines was arrested. It was clear to me that Hines was not being sentenced for the act of failing to provide his name, but that he was being sentenced for all these other things that he was accused of only after he was arrested. Noise, causing fear of Boston bomber and mass shootings, being rude to a librarian, trying to go into forbidden areas, an accusation of pornography that couldn't be seen on the displayed police body cam videos, and video recording. Judge Elsley even said, recording in a library, these cameras, and who does that? Judge Elsley did not communicate any understanding of the temporal component of reasonable suspicion. Prior to showing of library staff Carlo Jimenez's video statement to police on January 27th, Hines stated a relevance objection, stating that this occurred after the arrest and Mr. Jimenez had no contact with the police. Judge Elsley overruled the objection, ruling that it still mattered for reasonable suspicion. On cross-examination, Mr. Jimenez was asked these questions. Did you see Mr. Hines get arrested? I saw him being walked away in handcuffs. Did you talk to the police before Hines was arrested? No. Is the magazine room a forbidden area? No. Still, Judge Elsley repeated much of Mr. Jimenez's testimony in his sentencing. Prosecutor Benjamin showed his intention to make a knowingly false accusation against Hines. Mr. Benjamin exhibited several pictures of the magazine area with yellow caution tape prevented passage through parts of walls that were under construction. Mr. Benjamin displayed these pictures several times, ignoring the fact that the regular doorway to the magazine area was not blocked off, and officers Favors and Davis walked through that unblocked doorway upon entering the magazine area. When displaying Officer Davis's body-worn camera video and trial, Mr. Benjamin controlled the video as to prevent viewing of that entry through the doorway. Yeah, I suppose. I waited at the courthouse until Mr. Hines was walked away towards the police station in handcuffs. Judge Elsley was one of the final few to depart, and all who remained were just myself and the marshals. At that time, Officer Miller drove over from the direction of the police station, eyeing my red sedan rental car. Miller parked next to Hines's car and looked toward my car. Seeing that marshals were still there, Miller departed. The next day, on the edge of town in a supermarket's parking lot, I was monitored by two city police SUVs for about 10 minutes. One sat 200 yards from me, parked at a strange angle, pointed directly at me. I drove to the other side of the parking lot, and that SUV followed and repeated its same stance toward me. After feigning an exit from the supermarket parking lot and breaking line of sight, I reversed direction and drove behind the supermarket. I looked around the back corner of the supermarket and saw a second SUV pointed toward my previous position. That SUV then sped off down the road towards the Motel 6 I had stayed at the previous night. I reasoned that these police officers were aiming to stop me on a moving infraction and escalate the situation, in an act of revenge for the assistance I provided Mr. Hines. As further evidence of continued revenge-based harassment by the police, Hines sent me a message from jail on about April 19th, telling me that he had received a letter noticing that he was trespassed from the library, and that the letter was delivered to him in jail in person by Officer Miller. Alright, and that's that letter. So, yeah, this is kind of like an amicus brief, where some people are able to contact the courts through like the friend of the court program. Make them show their oath. Okay, that is cool that someone cared enough to be a wonderful witness. Alright, it's BWC. Don't turn on right away yet. It's recorded the officer coming into the library and walking all the way up to you, plus the entire event. Yeah, they turn off their cameras early and on late. It's just it's how they're trying to get around the use of the video technology that the cops are required to wear, but there's no serious requirement about how they record. So they turn them on late and off early. That's how they do it when they're real dirty. They can say, "Look, we have some video," but you can see them just abuse the power of the camera. They try to get around the camera. How much? Oh, Jack's got to get paid for this. I don't know. It's like this isn't the type of entertainment that pays for itself. I gotta pay my viewers. Yeah, that's to be decided at a later date. Right after the lawsuit, we'll divvy up the winnings. So that's a part of the amicus brief writing to the courts. I do want to put in the description the website for the Third Circuit, and then see how that works out. I guess I could take a break now. We'll probably stop. That's really